The question is that the motion be agreed to.
Mr Speaker.
I call the honourable member Moana Maki.
Thank you, Mr Speaker, and Labor will be opposing the amendments to the bills that make up the Crown Minerals Amendment Bill at the third reading. And it would be nice if everything that Minister Bridges just said was true, but unfortunately, largely it was a nice piece of fiction, because Minister Bridges might think that by merely saying environmental protections are important and paramount, that like some grand wizard it will automatically be so. But unfortunately that's not the reality. This piece of legislation seriously undermines the ability and the role of the Minister of Conservation to carry out the protection and preservation of the conservation estate. It seriously undermines the democratic rights of New Zealanders to protest. It is a missed opportunity. And I want to say up front, there are some things in this legislation which are good, and we welcome the health and safety changes that came out of the Pike River Commission of Inquiry. Those recommendations were picked up. That is positive. There are some changes to streamline and to evaluate some players in the industry, which we do welcome. But we are very disappointed that despite some promising approaches made to Labor by Minister Heatley when he held the portfolio at the first reading, that we were not able to find agreement on this legislation. And I want to pick up first of all the issue that the Minister raised last, which is the changes that are being made to introduce criminal penalties for protesters in our exclusive economic zone. Let us be quite clear, this does not plug a gap in our international obligations. And the reason it does not is because it only applies to protest vessels. It doesn't apply to the vessels that industry use. It doesn't apply to any other vessels carrying out an activity in the exclusive economic zone. And not only that, it doesn't just apply to protest vessels, it only applies to protest vessels that are protesting against oil and gas exploration. If this was about safety, if this was about plugging a gap in our legislation, then we would make it apply to everyone. Absolutely. And I want to know from the Minister why any vessel that is behaving in a way that would be illegal in our territorial waters under the Maritime Transport Act and the Crimes Act, why are those vessels not being covered in the exclusive economic zone? Why is it only one narrow class of vessel that's being covered? Surely if someone is behaving illegally or dangerously or recklessly, then they should be covered by this change. Why are they not, Minister? The Minister refused to answer that question all through the committee stage. No National Party member has even begun to address that issue, because this isn't about safety and this isn't about our international obligations. If it was, then this issue would have been raised with the Select Committee whilst we were considering the bill. Not once did officials raise this issue with the Select Committee. Instead, the Minister waited until the bill had been reported back to the House to drop this amendment and this SOP on the table. It has not had the proper scrutiny. It is incredibly bad lawmaking. It was embarrassing to see our Attorney-General come down to the House to defend it. This is a man whose job it is to uphold the Bill of Rights in New Zealand. And when we've had a number of eminent legal minds say this not only contravenes a number of our international obligations, but it also contravenes the New Zealand Bill of Rights. To see our Attorney-General come down, imply he had a legal opinion, which he had to admit he didn't have, and defend the indefensible was frankly embarrassing. Frankly embarrassing. And as I said throughout the committee stage, if the Minister had wanted to extend the Maritime Transport Act and the Crimes Act out into the exclusive economic zone, which is what the High Court said he should do, then Labor wouldn't have had a problem with that. Because if people are behaving dangerously, if lives are being put at risk, absolutely that needs to be dealt with. This does not deal with it. All this does is it's a PR stunt that sends a message to the oil companies that this government is prepared to do anything to get them here, is prepared to sacrifice any democratic rights or environmental standards in order to see this activity go ahead. We've already seen it with the exclusive economic zone legislation, which is the RMA version of version of the RMA that will apply in the exclusive economic zone. That doesn't comply with our international obligations. That is incredibly weak and permissive as well. We're seeing it in changes being touted around the Resource Management Act, a tilting of the playing field, constantly in favour of industry over the environment. And whilst jobs, says Minister Nick Smith, well, I think that this is going to turn out to be the biggest false economy that the national government has ever put in place. Because at the moment, New Zealanders have trust in the processes that are laid out both in the Crown Minerals Act and in the Resource Management Act. They trust the process, and therefore, if the outcome is that a mining project should go ahead, then they're less likely to want to oppose it if they trust the process. This is going to result in huge amounts of litigation. This is an absolute boom for judicial review. And I want to refer to one of the changes the bill makes. Currently, if a mining company wants to mine on Department of Conservation land, then that concession goes to the Minister of Conservation. That decision-making power is now being shared with the Minister of Energy. Now, the Minister of Energy's role under this bill is to promote mining. Now, does anyone not see a problem with a Minister of Energy who enthusiastically goes out and promotes mining? We had Minister Heatley, when he held the portfolio, in a general debate, doing a big rah-rah speech about the Denniston project in particular, as he was giving himself half the decision-making powers on whether that concession should go ahead. Did he not think that an organisation or an individual might think there was a slight little bit of predetermination of the decision there? That's why we've kept that power with the Minister of Conservation, because that's where it is most appropriately held. That is where you're going to get the least legal judicial review processes taken against the government. This is a false economy. It is not going to result in the outcomes that the government thinks is going to happen. But we come back to a fundamental point, which is, why are we doing this? We're doing this because for this government there is no plan B. This is it. They have put all their economic development eggs in this one basket. And so far we've seen ExxonMobil pull out, we've seen Petrobras pull out, we've seen Apache pull out. This is a high-risk area. It's serious money, and companies aren't going to invest unless the returns are going to be, unless one, they find something, and two, they find it in commercial amounts. And the likelihood of that is actually not very high. But this is all the government has. This is the plan. This and asset sales are the plan. So if it doesn't work, well, they're kind of stuffed, and they know that. So what we've seen is a progressive watering down of environmental regulation, watering down of environmental protections, now a watering down of people's democratic rights in order to grease the wheels as much as possible for this to go ahead, because they are desperate. Well, that is not a good basis for lawmaking or decision-making in this Parliament. And if we'd learned anything from the Rena disaster, from the Gulf of Mexico, it's that sometimes things go wrong, and we need to be absolutely prepared for that. And so instead of ramping ahead with this activity, scaling it up to extraordinary levels, this government should be asking themselves some very basic questions. One, do we have the capacity to deal with any disaster should it happen in New Zealand? And I think the Rena disaster showed us that perhaps our capacity to deal with it wasn't as great as we thought. That's number one. The second thing is the regulation that we have in place adequate to ensure the levels of environmental protection that New Zealanders expect? Now, we have confidence in the RMA. We don't have confidence in what the government are planning to do to it. We do not have confidence in the exclusive economic zone legislation. That legislation is dangerously weak, given that it governs the activity that is going to be carried out in some of the most difficult parts of New Zealand, out in deep water in the exclusive economic zone, 4 kilometres deep. Petrobras were looking at in the Ro-Kumara Basin. Gulf of Mexico was 1.4 kilometres. So we're talking seriously challenging technical difficulties if something goes wrong, and we have to be able to respond to that. We want to be sure that we're actually going to see benefits coming to New Zealand and coming to New Zealanders. And I accept that in Taranaki, this industry has been very good for economic development in that part of the country. That doesn't mean that there's a guarantee that that's going to be the case everywhere else. Petrobras said, when they were still looking at the East Coast, there were not going to be local jobs, and there were not going to be those local benefits that we got out of Taranaki. So people on the East Coast, and if any national MP, including our local MP or minister, had bothered to front up to any of the meetings that were held on this issue, then they would have been told, that the people on the East Coast were asking, why are we expected to carry all the environmental risk, the risk to our economy, the risk to our livelihoods, for absolutely no economic benefit on the East Coast? So there are a number of serious questions that the government simply are not asking, and they're not asking them because the answers may indicate that they might need to slow down, that there may be some regulatory gaps that need to be filled in order to provide that level of assurance to New Zealanders who've seen what have happened around both our own country and around the world with these environmental disasters and human disasters and tragedies. And instead, we're doing the exact opposite. Instead, what we're doing is we are stripping out some absolutely fundamental protections. What we're doing is we're skewing the playing field. The member is about to take his feet. I'd like to know, why is it that the economic benefit test only applies to the mining industry? Why should the tourism industry, who are operating in the Department of Conservation land, not be able to have that same economic benefit test applied? The fact is, we seem to be passing an awful lot of legislation for one industry in this country to the detriment of the environment and the democratic rights of New Zealanders.
I call the honourable member.
Thank you.
Jonathan